So I've made everyone co-host. I'm recording, and we're still waiting for one person, right?
Leah is in the waiting room. If we can get her in.
With which name? Like what name is she using?
I can't find Leah.
I ask her what name is she using, because I can't find Leah either.
Salah, can you ask? Summer, Professor Lynk مش قادر يفتح الفيديو تبعته.
Okay.
هلا تمام. Perfect. So we are all co-hosts?
Everyone is co-host. We're just waiting for to admit Leah to know the name she's using, and we're good to go.
Okay, I think let's start. And as Leah comes in, Samar, can you add her as a co-host and add everyone in now? Should we admit everyone?
Okay. I will admit everyone.
Make sure.
اسمعي الأسم مزال طوب.
As Leah comes in, Samar, can you add her as a co-host and add everyone in now? Should we admit everyone?
Who's opening? Like, I'm going to mute everyone now. And if someone wants to speak, please unmute. Okay. So now, okay. So I will admit everyone now. Do we know the name that Leah is using?
Yes, it's Mazal Tov.
Mazal Tov, okay. Okay, yeah.
في كمان ناس بيستنوا يدخلوا زي السحر.
I'm admitting everyone now. Okay, we can start, Nada.
Okay. Good afternoon. Thank you for joining our webinar entitled Salah Hamouri at Imminent Threat of Deportation from Jerusalem, Israel Must Be Held Accountable. My name is Nada Awad. I am the International Advocacy Officer at the Cairo Institute for Human Rights Studies. I will be moderating this discussion. Please note that English-French interpretation is provided. If you need French interpretation, please click on French to listen to us in French. Please use the chat section to ask written questions to the speakers, and we will address them after all participants have presented. I will start with a brief introduction. On the 3rd of September 2020, Palestinian French citizen Salah Hamouri was officially notified by the Israeli Ministry of the Interior of their intention to revoke his permanent residency status in Jerusalem for so-called breach of allegiance to the State of Israel, placing him at imminent risk of deportation. Previously, Israel banned Salah from the West Bank for almost 16 months and deported his wife El Salufar, a French national, separating Salah from his wife and son. If Israel revokes his residency and proceeds with his deportation, it will commit a war crime under the Rome Statute of the ICC and a grave breach of the 4th Geneva Convention. Article 49 of the 4th Geneva Convention prohibits individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to that of any other country, occupied or not. The punitive residency revocation of Salah Hamouri comes within the wider context of the Israeli residency and land policies aimed at altering the demography of the city of Jerusalem. International criminal law prohibits the serious crime of population transfer, including through demographic manipulation, which may amount to a war crime and a crime against humanity. In October 2017, in response to a question posed pursuant to the Freedom of Information Act by the Community Action Center, Al-Quds University, the Israeli Ministry of Interior affirmed that 13 residencies were punitively revoked based on the criteria of breach of allegiance to Israel, with the first case dating back to 2006. It was not until 2018 that the Israeli parliament amended the law, providing the legal basis for this illegal practice. The Israeli judicial system allows for these unlawful policies and practices to be carried out with impunity and with complete disregard for international law. Civil society has warned that the cementing of this criteria of punitive residency revocation in law will allow Israel to escalate its transfer of Palestinians in the pursuit of its demographic objectives in the city. Today, this legislation is being used to deport human rights defender Salah Hamouri. The targeting of human rights Salah Hamouri is also part and parcel of Israel's policy to silence any opposition to its apartheid regime and settler colonialism. According to the Apartheid Convention of 1973, the persecution of organizations and persons by depriving them of fundamental rights and freedoms because they oppose apartheid is considered one of the inhumane acts committed for the purpose of establishing and maintaining racial domination and oppression. I would like to thank the speakers who will cover the developments around the punitive residency revocation of Salah Hamouri as a case study of this policy. I now turn to Advocate Salah Hamouri, born in East Jerusalem to a Palestinian Jerusalemite father and a French mother. Salah Hamouri is a human rights defender and lawyer with Addameer Prisoner Support and Human Rights Association. He will share his testimony in French. Please select English if you need interpretation.
Bonsoir à toutes et à tous. Merci pour avoir organisé cette rencontre et merci pour toutes et à tous pour avoir participé à cette réunion. Comme vous le savez tous que moi, le 3 septembre 2020, j'ai reçu la décision du ministre de l'Intérieur israélien d'avoir l'intention de retirer ma carte de résidence dans un délai de 30 jours. Bon, la lettre est longue, mais les choses qui étaient dites dedans et pourquoi ils veulent retirer ma carte de résidence, c'est basé sur surtout mon dossier de 2005 pour lequel j'étais jugé 7 ans, plus mon dossier de détention administrative de 2007, plus il parle d'un dossier discret et il parle aussi que je suis membre du Front populaire de la libération de Palestine. C'est ce qui était dit dans cette lettre. Moi, je pense que cette décision qui était prise par le ministre de l'Intérieur, c'est pas juste une question juridique, mais aussi c'est hautement une question politique. Parce que je pense que cette décision, elle vise ma présence personnelle à Jérusalem, elle vise aussi les défendeurs de droits de l'homme qui sont à Jérusalem. La dangerosité de cette décision, que si elle passe aujourd'hui contre Salah Hamouri, elle peut passer aussi contre des centaines des anciens prisonniers qui sont en prison. Bon, directement, j'ai contacté les avocats. Aujourd'hui, je suis représenté par l'avocate Léa Tsemel et l'association Hamouri. C'est eux qui me présentent légalement. Notre dossier de défense, il a été fait il y a quelques jours. Je laisse la parole par rapport à ça à Léa, par rapport à la défense juridique. Mais moi, je pense que cette décision, elle est la continuation de la politique arbitraire israélienne qui me suit depuis plus que 20 ans. Moi, à partir de 2011, quand je suis sorti de prison en 2011, la pression israélienne n'a pas arrêté contre moi. J'ai reçu en 2014 trois ordres qui m'empêchent de rentrer en Cisjordanie pendant 18 mois. Après, il y avait l'arrestation de ma femme en 2016 et elle était envoyée en France. Puis j'ai été arrêté en 2017 pour 13 mois en détention administrative. puis j'ai été arrêté la fin de juin 2020 pour 9 jours d'interrogatoire. Je pense que cette pression israélienne, elle vise surtout qu'on arrive à un moment où on abandonne notre ville. On dit que moi, je dis ça suffit, et ça c'était clair pour moi, et que je dis ça suffit, que je pars vivre en France. Moi, ma décision, elle est déjà prête. Moi, la proposition israélienne qui a été faite en 2005 même, que j'accepte d'aller vivre en France 15 ans ou rester en prison pendant 7 ans, moi, j'ai refusé d'aller vivre en France pendant 7 ans parce que pour moi, l'idée de sortir de la Palestine est une idée inacceptable. La vie hors de ma ville natale de Jérusalem est une idée inacceptable. Nous, notre droit, c'est de vivre à Jérusalem, de continuer de vivre et grandir et poursuivre toute notre vie à Jérusalem. Moi, la décision, cette fois aussi, elle est prise avec plein de détermination que moi, je ne quitterai pas ma ville. Je continue tout mon combat pour gagner cette bataille parce que si moi, j'accepte aujourd'hui de sortir, cette cause-là, elle va poursuivre des centaines des autres prisonniers. Et pour moi, c'est inacceptable aussi de venir des réfugiés dans des autres pays, alors que notre droit, c'est de vivre à Jérusalem.
Thank you, Salah, for your testimony. I would like now to turn to Advocate Léa Tsemel, lawyer and legal representative of Salah Hamouri, who will present on the legal developments in the Israeli judicial system. The floor is yours, Léa.
Thank you. Hello. So yes, we defend Salah Hamouri, me, and also the Center for Human Rights, Human Individual Rights, המוקד להגנת הפרט. We do it together, and we try our best to bring about to abolish this terrible decision. The real roots of such a decision, it means to deport any person, Palestinian who is not a citizen, who is just a resident, to deport him because of the breach of the loyalty to the state of Israel. We know that in the old Zionist slogan, we used to say, a country without people, for people without a country, without a land. It meant the Jewish people are entitled to come to Palestine because there are people without a land, and there is a land that is totally empty of people. So for Zionism, the land was always empty. And yet, what can we do? It's not empty, it was never empty. And the indigenous who live here, the Palestinians, are here. And even after the 48 war, although a big part of them became refugees, another part is here to stay and stayed. And it is about 20% of the Israeli population nowadays. But the question is always there in the back of the mind, how to get rid of so many people. There was an attempt in '67 for another wave of deportation. It didn't work out totally. And then when people received the position that also Hamouri has of being a resident, not a citizen, it is always being a resident with a big question mark, because there are some basic demands from a resident that don't apply to citizens. For instance, if you go away for a long time to another country, or if you acquire another position, another citizenship or residency in another country, you can lose within 7 years the status of being a resident here. This is one of the ways to get rid of people. Another way used to be deportation for political reasons. I don't know if many of you remember, but there were waves of deporting young and older, a bit Palestinians who popped out as leaders, as potential leaders, as some potential fighters perhaps, and those would be gathered and deported to the neighboring countries. Sometimes they had to crawl to Jordan, sometimes they would be brought by buses to Lebanon to stay there. Nowadays, it seems that the possibility of deportation, though it is based in the law that Israel adopted, this possibility is void because the other countries doesn't accept them, because the last experience that Israel had when they deported more than 300 people who were suspected to be Hamas and Jihad to Lebanon, they built there the new cadre of Hamas and Jihad, and then they were forced to bring them back to the West Bank, and it developed immensely. So there is this new trick, I call it a trick, that in the law of entering Israel, it was amended in 2018 to enable the state to deny residency and now the residency for those people who are, as they say so, who are breaking the loyalty to the state of Israel. Breaking loyalty, what does it mean? It means almost everything, because it says in the next paragraph, any terror act, as it is described in the law against, in the law for the struggling the terror, which is a law from 2016, this law really describes terror or the terrorist organization as almost, say, anything that does any action against occupation. So it makes a very, very wide range of people who can be declared as those who break their loyalty to the state of Israel. So of course, once the Minister of Interior declares, as he did in this case, that he intends to deny Hamouri of his residency, I think that one of the basic things he had in mind is the fact that Hamouri is also a French citizen. So watch out. You cannot really deport a person and leave him without any status. So perhaps you are looking for people who have a specific status that can be, they belong to another state, and then it's much easier to deport them. Just as well as they deny residency if you have settled down and received, for instance, a British citizenship. It's a good reason to deny you of your residency here. But in order to attack Hamouri, they have to have some other reasons. It's not enough. So they are building this theory. Why should we, at this time, 2020, why should we deport him? And they say because once upon a time, he was sentenced for a conspiracy to attack a person who was at that time a chief rabbi of the Sephardic Jews. And par hasard, just by coincidence, the Ministry of Interior, who aims to deport him, is publishing at the same day that Hamouri receives his deportation order or threat of deportation, he publishes in the press many announcements saying that the Minister of Interior is acting in order to abolish the position of an activist in the Popular Front. They always mentioned a thing that is so long ago, that in the past, he was found guilty for this conspiracy I spoke about the chief rabbi. I will talk maybe later about the very small part he took in that so-called conspiracy that never passed the stage of talking and never became practical. But here we can see that the spokesperson of the Ministry of Interior puts in the headlines, in each headline, in each newspaper, the fact the minister there is acting in order to abolish the position of an activist in the Popular Front that intended to hit the Rabbi Ovadia. And of course, here is the picture of the Minister of Interior, and there are also pictures of this chief rabbi that passed away a long time ago, naturally, for natural reasons. So we see that they are attempting to get some political influence by expelling Salah Hamouri, and by, I would say, warming up an event that was long time ago and passed away. It's true that Salah Hamouri was also detained administratively. And you know very well, I'm sure, what does administrative detention mean? What are the roots of administrative detention? I'll say briefly, it is an old British law of the time of the mandate to enable the British who had the mandate over this area to hold people without a due trial, without legal procedure, to hold them as prisoners administratively, to renew their detention every 6 months. You don't have to have any proofs. You don't have to prove anything. You don't have these legal procedures. All you have to do is, here nowadays, the Minister of Defense in Israel or a military commander in the occupied territories has to issue an order and say that this person is a member of activist and he's dangerous, therefore we detain him. Now, they build nowadays Hamouri's deportation, I call it, on very old and unrealistic reasons. We have, of course, the possibility to go against it. And that's what we did. The Moked, the Center for Individual Rights, and us, the lawyers. And we say and claim you are not allowed, according to the international law, and as you said before, it is a war crime. You cannot deport people who are the indigenous. They are here. They were born here. They don't owe this loyalty to the state of Israel. Yes, they can be brought to trial if they break the law, but they don't owe this loyalty that has been broken. And more than that, I would say about Salah Hamouri himself. In his old case, when he was young and he was brought to trial and he was sentenced for 7 years, the court said specifically, it was a military court, and they said and insisted specifically that he was not too active in that case, that he was a very marginal participant, that he was willing to participate, and he was not trying to bring about progress to this case. On the contrary, he was trying to block it. This is a very good reason to use nowadays. And of course, as I said before, administrative detention cannot be taken into any consideration. It cannot become any part of the consideration of any minister or any court. So we are quite optimistic at the end, not because there is enormous justice around here, but because there are so many contradictions with the international law, with the legal situation, with Salah Hamouri and his past. What does he have to do with denial of residency? And we will bring it about also. We did it already in writing. Now we also have a hearing, and then we'll have all the legal possible procedures. But always in this very, very long path, we need the support of international organizations, human rights organizations. We need the support of people like you, all the listeners and all the activists. So we thank you ahead of time, and let's hope for the better times.
Thank you very much, Leah, for this analysis. I now turn to Mr. Omar Shakir, Israel and Palestine Director at Human Rights Watch. His presentation will focus on the Israeli policies targeting human rights defenders.
Thank you, Neda. It's a real honor to be with colleagues and allies and to see so many people around the world joining us. I think it is a sign of the very serious concern we have about what's happening with Salah Hamouri's case. I think you've heard explained very clearly by Neda and by Leah, and you'll hear more from my colleagues regarding what this says about Israel's Jerusalem policy, as well as what this is under international law. There's no ambiguity. International humanitarian law expressly forbids an occupying power from compelling people under occupation to pledge allegiance to it. There's really nothing complicated about that. But what I want to focus on in my brief remarks is why this event with Salah is part of a larger set of policies targeting human rights defenders. Because that analysis, I think, is really critical to understanding what's going on here. And Leah has given you some of the history that goes back decades of deportations. The reality here is human rights defenders in all shapes, sizes, and forms face a variety of tactics, not just by the Israeli government, by governments increasingly in Europe, in the United States, by non-governmental organizations. I want to very briefly sketch out the three kinds of attacks that we see and the way in which they manifest on the ground. The first, of course, which affects most people who are active in the human rights space in Israel-Palestine, is smear attacks or delegitimization. This affects everybody in different ways, shapes, and forms, even Israeli human rights groups. Israeli groups, including B'Tselem and Breaking the Silence, have been accused, I'm sure Leah has been accused, of being traitors or collaborators. We've seen laws, including the 2016 NGO law in Israel, that makes it very difficult to receive foreign funding and puts onerous requirements on groups that receive foreign funding. So that's one set of attacks. Again, different sorts of smears, but largely aimed to delegitimize human rights work for what it is. The second kind of attacks focus on support of boycotts or accusations of supporting boycotts or BDS. This one tends to focus on internationals as well as Palestinians. Within Israeli law, there's been a decade-long evolution here. In 2011, Israel passed a law that created a civil action, a cause of action, where you could sue somebody who you suffered damages from as a result of a boycott call. In 2017, the Israeli government took it a step further and passed an amendment to its law of entry that authorizes denying entry to people who call for boycotts of Israel. In 2019, the Israeli government used that law and went another step further and deported me, who is a representative of Human Rights Watch, an organization which, by the way, takes no position on boycotts anywhere in the world, deported me from where I had been based in Israel, Palestine for the previous 2.5 years. So civil cause of action, deny entry to BDS supporters, deport a human rights defender who doesn't take a position on BDS. And we already see the Interior Minister having made an announcement about studying the permanent residency of Omar Barghouthi, the founder of the BDS movement. Of course, many Palestinian NGOs have faced threats to their funding, in some cases lost funding, based on allegations that they support boycotts. And if they haven't lost funding, they've had to go through hoops, using much time and resources and energy to deflay this accusation. And we just saw the United States in the course of the last month declare that BDS and supporters of boycotts are anti-Semitic, which is even an escalation from the Israeli government line. While they haven't announced yet a list of which groups are going to make it to the blacklist, they've also been clear that this doesn't just apply to boycotts of Israel, but even those that for human rights reasons have concerns around settlements, which is a pretty mainstream international policy. Of course, this isn't just a Trump invention. This policy actually dates back to attacks on boycotts under the Obama administration, before that US states, efforts in Germany, elsewhere. But what's very clear is that there has been a gradual escalation based on this tactic. And it's and the anti-Semitism front, the IHRA definition is the newest frontier. And the final thing I want to talk about, category of attacks, and this will bring us back to Salah's case, is support for violence, terror, security-based arguments. And of course, Palestinians face this in the most significant way, shape, and form. And it's not just smear attacks, but it can lead to really serious consequences. Before I get into the specifics, it's worth noting that much of this is rooted in Israeli military law that's been in place in the West Bank for more than half a century. For example, Israeli military law bans with criminal sentences up to 10 years, activities like peaceful protest without a permit, waving a flag, being involved with a hostile organization, which the Israeli government has defined as more than 400 organizations to fit within it, including every major Palestinian political group. And that is manifested in every day a suspension of basic civil rights for Palestinians in the West Bank. But it's not just that, right? It doesn't just stop at the fact that Palestinians in the West Bank haven't had basic civil rights for more than 50 years, involved in a political group, waving a flag. We've seen groups like Addameer who've had their offices raided. We've seen travel bans issued, again, not just to Palestinian NGOs. Laith Abu Ziyad of Amnesty International, a Palestinian that holds a West Bank ID, was denied a permit to visit his mother, who was 3 kilometers away in a hospital suffering from cancer, wasn't able to be by her side as she passed away in Jerusalem, denied a permit to leave the occupied West Bank. Sha'wan Jabarin, one of the foremost Palestinian human rights defenders for decades, had a travel ban related to his human rights work. And of course, we have arrest and administrative detention. Khalid Jarrar, who has been in administrative detention again for many months on end. Salah himself, who faced long periods of this. And then we get to Salah's case, which in some ways is new, but not new. But this idea of revoking permanent residency for Jerusalemite for a breach of allegiance is an escalation. And I think I want to end by just saying that much. When I was on the ground, many of you know, I spent 1.5 years fighting to avoid my deportation. And what I kept telling people is that this was going to be a signal to the Israeli government. It was a test case. Salah is a test case. My case was a test case. My deportation has led to many subsequent maneuvers. When you look at the reality in the West Bank, when you look at some of these designations taking place, Salah's case is a test one. It's important that we're vocal, principled, and I hope you'll continue to raise your voices.
Thank you very much, Omar. I now turn to Professor Michael Lynk, United Nations Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967. Professor Lynk will address the issue of third state responsibility in the context of this webinar.
Thank you very much for that, Nada, and thank you for everybody who has been involved in this webinar for the invitation to speak today on this panel regarding the threatened revocation by the government of Israel of Mr. Salah Hamouri's residency status in Jerusalem. As UN Special Rapporteur on the human rights situation in the occupied Palestinian territory, I am deeply troubled by several matters relating to his case. First, Mr. Hamouri has been subject to a pattern of repeated detentions by the Israeli government through the legal instrument of administrative detention. This blunt instrument has been widely, some may even say promiscuously, relied upon by the Israeli government through its 53-year-old occupation of the Palestinian territory to imprison many thousands of Palestinians without charges, without trials, without findings of guilt, and without fairness. Under both the Fourth Geneva Convention and international human rights law, an occupying power cannot arbitrarily detain a civilian of the protected population unless the security requirements make it absolutely necessary. The reasons justifying administrative detention must be, according to international law, serious and legitimate. If a person is to be administratively detained, he must nevertheless have access to procedural and substantive justice as possible in the circumstances. Israel's insistent reliance on administrative detention has been regularly criticized by international and regional human rights bodies. A country which states it is guided by the rule of law, but which employs a systematic use of administrative detention over millions of people that it rules, must be judged by this extraordinary gap between promise and performance. The second troubling feature of Mr. Hamouri's case is Israel's threat to revoke his permanent residency status and to force him to involuntarily leave his homeland. My understanding is that Mr. Hamouri was born in East Jerusalem and has lived there his entire life. In any country which genuinely follows the rule of law, this would grant him the full rights of a citizen, or in the case of occupation, full rights to remain where he lives under the protection of international law. As such, he or she would have the freedoms as well as the duties and responsibilities of a rights-bearing person under law, including the right to be recognized and inalienable residency status. This is not the case for East Jerusalemite Palestinians. They are deemed to be permanent residents with rights that fall well short of a full citizen. Indeed, the term permanent in this case does not have the solid, impermeable, inalienable status that it might indicate. East Jerusalemite Palestinians who are deemed to be permanent residents are in a legal limbo. They have access to a range of social benefits as well as to the right to live in Israel, but they do not, under Israeli law, have an irrevocable status to live where they were born. According to human rights organizations, since 1967, more than 14,000 East Jerusalemite Palestinians have had their residency revoked, some for reasons of political involvement, some for having lived abroad for more than 7 years without returning, some for not having Jerusalem as the center of life, and some for other reasons. Let us be clear. Residency status for an indigenous person who was born and has lived in his or her homeland is not a political favor. It is not a discretionary status. It is a fundamental right to enjoy a true permanency in residential status with the indigenous population. Like citizenship, it is either irrevocable or can only be revoked on the narrowest and most justified of reasons. The illegitimacy of this policy of canceling the residency rights of East Jerusalemite Palestinians has resulted in entrenched discrimination, an impermissible system of unequal rights and hierarchical status that has no place either in a modern democracy or in a territory under occupation. In contrast, Jerusalemites who are Israeli citizens are not required to prove that they maintain their center of life in the city in order to secure and defend their legal status. Israel has treated the Palestinians of East Jerusalem as belonging to a legal netherworld. They enjoy neither the full rights of protected citizens under occupation, nor do they have the rights equivalent to Israeli citizens of Jerusalem. This indeterminate status may suit Israel's position of wanting territorial sovereignty over East Jerusalem, while conferring a substantially diminished legal status to the Palestinians living there. But this is in sharp contrast to the requirements of the rule of law. I am particularly concerned with what other speakers have mentioned regarding the amendments adopted by the Israeli Knesset in 2018 in its entry to Israel legislation. In these amendments, the Knesset granted broad discretion to the Israeli Ministry of the Interior to revoke the residency status of Palestinians if they, in the opinion of the minister, have breached their obligation of allegiance and loyalty to Israel. Loyalty and allegiance is a political concept, particularly when left undefined and in the hands of political ministers and conservative courts to implement, invariably become slippery terms that disfigure human rights and stain all those who enforce them. What does international law require? First, Israel is occupied territory and has been since 1967. Accordingly, Israel is in violation of Article 64 of the Fourth Geneva Convention by extending its claim of sovereignty over occupied territory and attempting to extend its legislation on resident status to East Jerusalem. Second, occupying powers are prohibited from demanding allegiance from the occupied population. They can be expected to maintain security, but requiring loyalty to the occupying power is well beyond their authority. And third, revoking residency rights of the indigenous population or transferring civilians of the protected population out of the occupied territory violates the basic human right of a people to leave, return to, and remain in their homeland. The international community bears a special responsibility to ensure that Israel complies with its obligations as the occupied power. Common Article number 1 of the 4 Geneva Conventions requires the high contracting parties to the conventions to ensure respect by each other and by occupying powers for the strict requirements and prohibitions in international humanitarian law. This means, among other things, calling Israel to account for the yawning gap between its responsibilities and its actual compliance. The United Nations and other authoritative international institutions have spoken, often with lucidity and incisiveness, about the incompatibility of the Israeli occupation with international law and basic rights-based principles. On a number of occasions, they have warned Israel about its defiance of and non-compliance with Security Council, General Assembly, and Human Rights Council resolutions. But rarely have they ever taken actual steps to hold Israel accountable, particularly through effective countermeasures and sanctions for its obstructive policies and practices concerning the occupation. International law is not meant to be an umbrella that folds up at the first hint of rain. May I conclude by saying that Salah Hamouri's case is yet another test for us all to ensure that imperishable rights and obligations are insisted upon, complied with, and protected. Thank you very much.
Thank you very much, Professor Lynk. I now turn to Ms. Shahd Qaddoura, Legal Research and Advocacy Officer at Al-Haq. She will discuss the Israeli policy of residency revocation as a tool of transfer of Palestinians from Jerusalem.
Thank you, Nada, and thank you everyone for joining us. We've already heard some really great presentations, and I hope with this one what we can do is understand the illegality of Israel's intention to revoke Salah's residency status for so-called breach of allegiance under international law. Omar gave a very comprehensive overview of Israeli attacks against human rights defenders, and I think it is within this context that we need to address Salah's case. Human rights defenders have been long targeted for advocating for Palestinians and for seeking justice and accountability for violations of Palestinian rights. Israel has and is doing so in order to maintain its apartheid regime over the Palestinian people. As previously highlighted by different colleagues, this attack on Salah is not an isolated incident. He was previously harassed by the Israeli occupying authorities, and so were many other human rights defenders. To start, I think it's very important to address and acknowledge how and why this policy came to be. Israel has long used residency revocation as a tool to forcibly transfer Palestinians from East Jerusalem. Israel has and is doing so with the aim to reduce and eliminate the Palestinian presence in East Jerusalem and therefore altering demographic facts on the ground. Population transfer and demographic manipulation manifested through Israeli laws, policies, and practices, including its entry into Israel law of 1952, is key to Israel's development and maintenance of an institutionalized regime of oppression and apartheid over the Palestinian people as a whole. This law is concerned with the entry of non-citizens into Israel and grants favored treatment to Jewish immigrants under the law of return. At the same time, it establishes the dangerous permanent resident status imposed upon the Palestinian people in the occupied East Jerusalem. Of course, this leaves the Palestinian population in East Jerusalem living with the risk of residency revocation, which leads to their forcible transfer from the city. Since 1967, Israel has created and continuously expanded the criteria for revoking the residency status of Palestinians from Jerusalem. Between 1967 and 1995, Palestinians in East Jerusalem were under the threat of losing their residency status by settling outside of Israel. So basically that means if Palestinians from East Jerusalem settled outside of Israel for a period of 7 years or received the status of resident or citizen in another country, they will have their residency.
Can you remove maybe your speakers because there's a sound when you speak?
Okay. Is this better? Perfect. And after 1995 and since 1995, Israel had broadened the criteria and introduced the Center of Life policy. So now Palestinians from East Jerusalem could lose their residency status if they cannot provide their Center of Life policy. Center of Life is in Jerusalem, even if they were residing abroad for less than 7 years, and even if they did not obtain residency status or citizenship of a foreign country. Since 2018, the Israeli Minister of Interior has been granted a broad authority to punitively revoke Palestinians' residency status, including for breach of allegiance. So this policy was introduced into the Israeli law in 2018, but regardless of that, Israeli Interior Ministry acknowledged that it had revoked the residency status of 13 Palestinians on the basis of breach of allegiance by October 2017. So the first punitive residency revocation was carried out in 2006 when the Minister of Interior revoked the residency status of 3 elected members of the Palestinian Legislative Council and the former Palestinian Minister of Jerusalem, claiming that they had breached allegiance to the State of Israel. They were forcibly transferred outside of East Jerusalem to other parts of the occupied Palestinian territory. So how can we translate this policy when we talk about international law? First of all, and as Professor Lynk highlighted, Israel is the occupying power of the Palestinian territory, which consists of the West Bank, including East Jerusalem and the Gaza Strip. Therefore, the strict rules of the laws of occupation apply. These rules of laws are particularly found in the Fourth Geneva Convention and in the Rome Statute of the ICC. From there, residency revocations, including punitive revocations, violate numerous provisions of international human rights law, but also international humanitarian law. Revocation of residency leads to forcible transfer, and forcible transfer is considered a war crime under the Rome Statute of the International Criminal Court and a grave breach of the Fourth Geneva Convention. And also, if we look at how Israel uses residency revocation, we notice that it's being used as a part of a widespread and systematic policy to transfer the protected Palestinian population. And as such, it may further amount to a crime against humanity as provided by the Rome Statute. As previously highlighted by Professor Lynk, between 1967 and 2017, about 14,500 Palestinians had their residency revoked by the Israeli occupying authorities. Now, when we talk about Israel's policy of punitive residency revocation, I just want to highlight 2 points with respect to their illegality. First of all, Israel, as an occupying power, may not act as a sovereign legislator or extend its own legislation over the occupied territory. The Palestinian population in East Jerusalem is a protected population, and therefore Palestinians in East Jerusalem are not to be held by the Israeli domestic laws. The second point I'd like to make on this is that the problem isn't only with the act, but also with the reasoning of the action. So the mere fact that Israel is basing this residency revocation on a breach of allegiance is wrong. International humanitarian law explicitly forbids the occupying power from demanding allegiance from the occupied population. Just to wrap up, I want to reassert that the Israeli residency policy revocation are yet another critical example of Israel's regime of racial domination and oppression. These policies are designed to maintain an unsafe legal status for Palestinians in East Jerusalem and to uphold an Israeli Jewish demographic majority in the city. Israel will continue its brutal and oppressive occupation and will continue to rapidly expand the colonization and the de facto annexation while violating Palestinian human rights as long as it enjoys its culture of impunity. Human rights defenders, just like Salah Hamouri, will continue to endure harassment for raising opposition to Israeli policies and practices as long as Israel is not held accountable. The Israeli judicial system is clearly complicit in the implementation of the unlawful policies and practices which are in violation of international law.
and further ensure the continued impunity of Israeli officials involved in the violating of the rights of the Palestinians. As such, it is very important that the international community immediately address the Israeli violations and adhere to their third state obligations, such as Professor Lynk highlighted earlier. The international community must take concrete actions to hold Israel accountable to its human rights violations and grave violations of international law. Thank you.
Thank you, Shahd. And now I move to Ms. Anne Toyon, Vice President of Association France-Palestine Solidarité, who will speak on behalf of a group of French organizations, including the French Plateforme, on the campaign they are leading in France on the case of Salah Hamouri. She will speak in French. Please turn on the interpretation if needed. On t'entend pas, Anne.
Voilà.
Anne, voilà, c'est bon.
C'est toi qui me remettais le micro. Bonjour à toutes et à tous. Donc, beaucoup de choses ont déjà été dites. Je vais donc centrer mon intervention sur la mobilisation qui se développe depuis plus de 12 ans maintenant autour de la situation de Salah Hamouri. Les Français ont découvert le jeune visage de Salah Hamouri il y a une douzaine d'années, quand commença la première campagne de solidarité pour soutenir ce très jeune homme, français et palestinien, qui se trouvait dans les prisons israéliennes. Un comité de soutien co-présidé par Inkouri et par Stéphane Hessel avait été mis en place et débuta une large campagne pour exiger sa libération. Pendant des mois et des années, nous avons été présents dans les rues et sur les places de France avec des portraits de Salah Hamouri pour faire connaître sa situation, pour exiger sa libération. Nous avons appelé les autorités françaises et les parlementaires, les élus de tous bords, à agir pour que cesse l'injustice qui lui était faite par Israël. Tous les jours, le visage de Salah Hamouri est resté à la une du journal L'Humanité jusqu'à sa libération. Pendant cette longue première période d'incarcération, Salah a joué un rôle important dans le lien entre les prisonniers politiques palestiniens et le monde extérieur en France. Des milliers de personnes écrivaient à des prisonniers. Cette campagne s'est poursuivie après sa libération. Les prisonniers politiques palestiniens devaient savoir que même une fois Salah Hamouri libéré, on ne les oublierait pas en France. Cette campagne dite de parrainage avait 3 objectifs. Bien sûr, le soutien aux prisonniers, mais aussi montrer aux autorités israéliennes que nous savions, et également faire connaître aux autorités françaises la solidarité avec les prisonniers politiques palestiniens. Lorsqu'il a finalement été libéré et qu'il a pu venir en France, Salah Hamouri est devenu en quelque sorte un porte-parole de ses anciens co-détenus, comme il le leur avait promis lorsqu'il les a quittés. Il a sillonné la France pendant plusieurs semaines pour raconter, pour dénoncer. Nous avons alors découvert l'ampleur des atrocités commises par Israël contre les prisonniers politiques palestiniens. Nous avons découvert l'ampleur de la politique d'oppression d'Israël à l'encontre des Palestiniens par le biais d'arrestations arbitraires, y compris de jeunes enfants. Nous avons entendu parler des conditions d'arrestation, de la torture, des violations des droits fondamentaux et du recours abusif par Israël à la détention administrative. Nous avons donc pu, dans la suite de Salah Hamouri, informer la population française de la situation des prisonniers politiques palestiniens. Malheureusement pour lui, Salah Hamouri allait par la suite mettre en lumière, à travers sa situation personnelle, d'autres pratiques d'Israël, d'autres pratiques de domination et d'oppression du peuple palestinien. Lorsqu'il a décidé de se marier avec une Française, Salah Hamouri s'est trouvé comme de nombreux Palestiniens dans l'impossibilité de fonder une famille et de vivre chez lui, à Jérusalem, en famille. Sa femme et son enfant à naître étaient accusés d'être des dangers pour la sécurité d'Israël. Les Français ont découvert qu'un enfant, avant d'être né, était traité par Israël comme un terroriste, au motif que son père refuse l'occupation de sa terre et qu'il est un défenseur des droits humains. Les Français ont découvert qu'une femme française tombée amoureuse d'un homme palestinien ne peut envisager de fonder une famille avec lui, à moins d'être séparée de lui la plupart du temps, ou même séparée de lui pour de très longues périodes, selon les décisions arbitraires de l'occupant, qui depuis des années tente de rendre la vie de Salah la plus insupportable possible afin qu'il renonce à ses droits en tant que Palestinien. Et puis, il y a eu les autres arrestations arbitraires, la détention administrative. Chaque fois, la mobilisation s'est remise en place immédiatement en France et les portraits de Salah sont revenus fleurir les rues de nos villes. En décembre 2017, la campagne 1000 élus pour Salah avait permis de mobiliser de nombreux élus, bien plus de 1000 en fait, et a donné de la visibilité à la campagne pour sa libération. Maintenant, c'est la vie des Palestiniens de Jérusalem que les Français découvrent à travers le nouveau harcèlement dont Salah est victime. Pour un peuple comme le nôtre, qui a vécu pendant 5 trop longues années sous occupation militaire, et dont une partie a résisté à cette occupation, apprendre qu'Israël exige l'allégeance d'une population vivant sous occupation militaire, cela résonne d'une manière très forte. En accord avec le droit international, nous le clamons haut et fort. Non, un peuple occupé n'est pas tenu de faire allégeance à l'occupant. Bien au contraire, le droit international dit que c'est son droit de lutter contre cette occupation et c'est bien ce droit qui lui est nié par Israël. Salah Hamouri est certes palestinien, mais il est aussi français. La situation qui lui est faite doit mobiliser au-delà du mouvement de solidarité internationale. L'AFPS a lancé une campagne d'interpellation des parlementaires afin que les politiques s'emparent de cette question qui doit être prise dans sa globalité. Salah Hamouri n'est qu'un exemple parmi tant d'autres des violations incessantes du droit par Israël. La diplomatie française a rapidement réagi à cette nouvelle menace contre Salah Hamouri pour demander que ses droits soient respectés. Nous le saluons. Nous savons et nous saluons les interventions de nos autorités consulaires sur le terrain. Mais force est de constater que pour la situation faite à Salah, comme pour les violations permanentes du droit, il faudra des interventions d'un autre registre pour faire plier Israël. Si les condamnations verbales et le rappel au droit avaient une quelconque influence sur Netanyahou, cela se saurait depuis longtemps. Il s'agit bien de mettre fin à l'impunité d'Israël. La Cour pénale internationale est un outil très précieux pour y parvenir, et la France doit la protéger contre les pressions inadmissibles exercées par Israël et les États-Unis à son encontre, et tout particulièrement à l'encontre de la procureure Fatou Bensouda. Mettre fin à l'impunité d'Israël, cela peut passer par une simple application du droit, en refusant que les produits des colonies entrent sur notre territoire. Cela peut passer aussi par le désinvestissement des entreprises françaises liées à la politique d'apartheid israélienne. Cela peut également passer par des sanctions à l'égard d'Israël et à la suspension des coopérations militaires et sécuritaires tant qu'Israël ne respectera pas le droit international. Les voies ne manquent pas pour s'engager dans cette direction. Nous en appelons donc solennellement à nos autorités afin que le chemin de l'application du droit et de l'égalité des droits s'ouvre enfin. Dans une semaine, nous commémorerons la Déclaration universelle des droits de l'homme. Ces droits sont quasiment niés au peuple palestinien par l'État d'Israël. Ces droits sont quasiment tous niés à Salah Hamouri, citoyen français par l'État d'Israël. Le combat que nous menons pour Salah est indissociable de celui que nous menons pour la reconnaissance des droits du peuple palestinien dans son ensemble et nous continuerons à le mener. Je vous remercie.
Merci beaucoup, Anne. I go back to English. I would like to thank the speakers for their invaluable contribution to this webinar. We'd like to note that Professor Lynk had to leave us after his presentation, but that if you have any questions, please feel free to write them in the chat. As mentioned by colleagues, civil society organizations from around the world have called on the international community to take effective measures to ensure that Israel does not pursue the crime of population transfer by deporting the human rights defender Salah Hamouri from Jerusalem. The international community, as we have heard by colleagues, also needs to urgently address the root causes of the issue at hand: Israel's settler colonialism, the policies of population transfer within the larger apartheid context, and take effective measures to put an end to Israel's impunity. I will now turn to questions. If anyone has a question, they can write it, or I can give speakers concluding remarks, if not. Maybe we can start with concluding remarks by speakers in the same order. Salah, would you like to conclude?
Moi, pour conclure, je veux dire que vraiment merci pour tout ce qui a été fait pour le travail aujourd'hui, pour cette réunion. Ce que je veux finir avec, c'est l'importance qu'il faut savoir que le travail au niveau international qui est fait, c'est un travail très, très important. La pression sur l'état de l'occupation israélienne doit augmenter chaque jour parce que avec cette solidarité internationale, avec la pression sur l'état de l'occupation israélienne, on peut les obliger à reculer de ces décisions arbitraires. Alors, chacun d'entre nous, parmi nous, dans son pays, il doit utiliser tous les moyens possibles pour organiser cette pression sur l'État d'Israël, parce qu'avec toutes nos expériences, l'état de l'occupation, elle recule juste sous la pression. S'il n'y a pas pression, s'ils ne sentent pas la pression immédiate, s'ils ne sentent pas qu'eux, ils sont en danger, ils ne vont pas reculer. Alors, c'est très, très important d'augmenter la question de la mobilisation bien, sur la cause du Salah Hamouri, mais aussi surtout les questions qui sont posées sur la table.
Thank you, Salah. I now turn to Léa, if you would like to conclude. We cannot hear you.
I know. Okay, you can hear me now. Yes, I would like to say that, relatively speaking, really, excuse me, Salah. Salah is a very small terrorist. I'm not talking about him. I have this deep belief that perhaps we can succeed in his case. But first of all, we do need the support, the international support, that's for sure. And we do need the international support for coming cases, because there are some cases that are like test cases, but what will happen afterwards? Once it could be, I don't know, confirmed in an Israeli court, it can lead to masses. Everyone who ever was sentenced for being a member in an illegal organization or actions like this. So it's not Salah by himself. Salah is now the leading figure, but it can be many, many Salahs, many, many, many Salahs. And that's what we have in mind, and that's what we should be aware of. So, yes, there are many, many breaches of the international law. And the feeling is that at this time we cannot be left alone. We need the help of the international societies. That's what we really need, because we are in a very poor situation right now. The Israeli democracy is in a very poor situation. The issue of human rights is right now in the corner. You can see all the daily demonstrations against Netanyahu and how the reactions are. Whoever follows it can realize that we are in a mess. So please help us.
Thank you. Omar, would you like to conclude?
Sure. Just I you want that. I mean, look, take a step back.
The sound is bad. I don't know if there's like an echo. Can you try now?
No. Okay, maybe somebody else can get involved.
Okay. Maybe, Shahd, would it be possible to tell us a little bit, because we have questions about the UN, could you tell us about the actions that were done, the oral statements and the special procedure submission that was made by Al-Haq and others?
Yes, definitely. So 13 Palestinian and regional human rights organizations have submitted an urgent appeal to the special procedures, highlighting the case of Salah and, of course, putting it in the context of the bigger Israeli policy. As colleagues have previously highlighted, this is a test case, but also the Israeli policy of residency revocation has been implemented since 1967. And so this urgent appeal was sent back in September, and we've also addressed the Human Rights Council. I think it was more than 50 human rights organizations, Palestinian, regional, and international civil society organizations that have addressed the Human Rights Council, addressing the case of Salah, but also putting it in the context of other harassments that human rights defenders endure by the Israeli occupying authorities.
Thank you. Omar, would you like to try?
Sure, is it clear now? Okay, great. What I was just gonna say is I know we have many folks here that are following the reality on the ground, and I agree that what's happening to Salah has to be seen not only in the wider context of human rights defenders, but of the wider context of the reality on the ground. We're seeing unprecedented illegal settlement construction taking place in all parts, of the West Bank and East Jerusalem at levels that we, really haven't seen in recent years. There are really concerning possibilities when it comes to demolitions, not only Khan al-Ahmar, which is always in the news, but in the South Hebron Hills. We're seeing efforts to continue to entrench Israel's discriminatory two-tiered system in the West Bank. Efforts for businesses to, like Heidelberg in Germany, that's expanding its quarry. Countries that are today in the news reports, Bahrain not acknowledging the line between goods from the West Bank and Israel proper. So I think it's a moment to sort of to push on all these fronts. Especially as we enter, in 2021, a time in which there'll be a desire to turn back the clock, to think that just by sort of undoing the excesses of the Trump administration's approach, that we can somehow get back on track. And the Palestinian Authority, unfortunately, appears all too willing to go back to the way it was before 2016. But that way has failed Palestinians for decades. They continue to face systematic rights abuse and impunity. It's really time for a new approach, one that's grounded in accountability and the sorts of human rights measures that a situation of this gravity warrants. Human Rights Watch works in 100 countries. When we see abuses of the natures we see taking place every day in Israel and Palestine, we call for action, accountability, and I think there's a need for that. And Salah's case is one of the many fronts of significant concern because it's people like Salah that need to be on the ground so that we can fight everything else. So when you're speaking out for human rights defenders, it's not only because it's significant, it's not only because of what's happening in Jerusalem, it's because this is part of an effort to muzzle the work of people like Addameer, like Salah, like so many others that are trying to sort of continue to raise these important issues. So I'll just conclude on that point.
Thank you very much, Omar. Anne, would you like to conclude as well?
Oui, je peux effectivement rajouter un petit mot pour aller dans le sens de ce que Salah a précisé. Il faut continuer la pression sur les autorités et ça passe par la pression sur les autorités françaises et ça passe par j'allais dire la pression, mais la pression des parlementaires. On n'en est même pas à ce niveau-là sur certains parlementaires en France. On en est juste à ce que à faire connaître la réalité de ce qui se passe en Palestine à nos parlementaires. Donc, j'invite toutes et tous à continuer à utiliser cet outil d'interpellation que nous avons mis en place il y a maintenant 3 semaines pour interpeller les parlementaires français afin qu'ils fassent pression sur les autorités françaises, pour qu'elles fassent pression sur les autorités israéliennes. Nous avons à peu près, je crois, pour l'instant, 15 000 messages qui ont été envoyés aux parlementaires français. Ça n'est quand même pas rien, avec énormément de retours de parlementaires, mais des parlementaires qui nous disent avoir pris bonne note et rappeler la position de la France qui est l'application du droit international. C'est ce que je disais tout à l'heure. Les paroles, c'est très intéressant. Le rappel au droit, c'est très intéressant, mais Israël n'en a que faire. Donc, ce qu'il faut vraiment, ce sont de vraies pressions et de vraies prises de position de la France et de positions courageuses, et ça passe par des sanctions contre Israël. Israël n'entend pas la voix du discours, du dialogue. Israël entend la voix de la pression. Donc, nous attendons de nos autorités françaises qu'elles fassent ce qu'il y a à faire pour que cesse l'impunité d'Israël.
Thank you. And I see that there are some questions asking if the fact that Salah has a French passport makes it easier to deport the person. I can answer maybe quickly this one. If Salah didn't have a French passport, in other cases where we had residency revocations, for the example, the members of the Palestinian Legislative Council in 2006, they were forcibly transferred to Ramallah, to the West Bank. So in this case, the forcible transfer still occurs. It's just that it's to the occupied territory outside of Jerusalem rather than to France. There was another question, and I don't know if anyone has any idea and can update us on the diplomatic level, the actions made by France. If anyone has more information of what France has done on the diplomatic level.
Sur le niveau diplomatique français, il y avait une prise de position par le Quai d'Orsay 48 heures après la décision du ministre quand je l'ai reçue. Par les informations, on a su que l'ambassadeur français il avait une réunion avec le ministre des Affaires étrangères de l'État de l'occupation qui a demandé d'annuler cette décision. Moi, je suis en contact avec le consulat français. On avait eu, il y a 2 réunions, ils ont eu lieu. Il y a une troisième réunion normalement avant le 15, elle va avoir lieu. Je sais qu'il y a des lettres qui étaient envoyées par les autorités françaises qui demandent à l'occupation israélienne de reculer de cette décision. Pour moi, c'est ce qui a été dit jusqu'à le moment, c'est ce qui a été dit, ce qui a été fait au niveau diplomatique.
Merci Salah. Je pense, I think if there are no other questions, I would really want to thank all the participants to this event and thank the speakers very much for their interventions. And we look forward to hearing much more lobbying and advocacy around the case of Salah and to oppose all forcible transfer of Palestinian population in Jerusalem and the policies that are targeting the Palestinian population as a whole that our organization are monitoring and documenting and working on. Thank you very much to everyone. Have a good afternoon.
Thank you. Thank you. You were really lovely. Thank you very much.